Good afternoon, everyone. Can you hear me? We're just checking, given our track record with some of the audio. Okay, that's why I'm checking. Can you hear me good? Who said they couldn't hear me? Raise your hand. Who was that? Can you hear me now? Better? Okay. If at any time you cannot hear me, or any of our other presenters, please let us know, and we will either speak up or try to grab somebody to help with our technical problems here. So good afternoon, everybody, and thank you for coming. My name is Sophia McCardle. I'm with the Office of Post-Secondary Education Policy Planning and Innovation. I'm joined today by my colleagues Greg Martin, who's also from the same office as myself, and Dave Musser from the Office of Federal Student Aid. Today, we will be providing a regulatory update, and I should get our clicker, make sure it works, on two big topics: state authorization for distance education and distance education. A lot of people wondered if that was really the title. That really was the title. And we're going to start with state authorization of distance education. But before we dive into state authorization of distance education, I want to provide some background and content for state authorization. So first, let's talk about the state authorization requirement in general. Why is there a requirement for state authorization? Well, under the Higher Education Act, for an institution in any state to be eligible to participate in federal student aid programs, it must be legally authorized by the state to provide post-secondary education. So, simply put, state authorization is a requirement for an institution of higher education to be eligible for federal funding. Section 101A2 of the HEA defines an institution of higher education to mean, in part, an educational institution in any state that is legally authorized within a state to provide a program of education beyond secondary education. And Section 201A2 of the HEA provides that a proprietary institution of higher education and a post-secondary vocational institution must be legally authorized within a state to provide a program of education beyond secondary education. So, bottom line is that the HEA requires institutions to have approval from states where they operate to provide post-secondary educational programs. State oversight through obtaining approval to offer post-secondary education. Let me just make sure this is not working very good. All right, okay, I'm gonna go back. State oversight through obtaining approval to offer post-secondary education and by state regulatory agency or ongoing activities play an important role in protecting students. Although legal authorization by a state has always been required and is a basic building block of institutional eligibility for federal student aid, before October of 2010, there was no definition or description in the regulations. So, the development of the state authorization regulations occurred as a part of negotiated rulemaking on program integrity issues way back in 2009-10, with resulting final regulations published October 29, 2010, with an effective date of July 1, 2011. These final regulations clarified that state approval to offer post-secondary educational programs is a substantive requirement where the state is expected to have an active role in approving an institution and monitoring complaints from the public about its operations and responding appropriately. So here are the links to these particular regulations for those of you that haven't had the pleasure of looking at them yet. So what were these regulations doing? For institutional eligibility purposes for federal programs, the state authorization regulations assure a state role in authorizing post-secondary institutions and clarify what is required for an institution to be considered legally authorized by the state. Let's talk about this first point a bit, about assuring the state role in authorizing post-secondary institutions. The Higher Education Act envisioned a triad of oversight by the federal government, in the form of the Department of Education, the states, and accrediting agencies. The regulations clarified the roles of each of these participants in establishing an institution's eligibility for federal programs. It's also important to remember that the department regulates institutions, not states. Just to be clear, one more time, the department does not provide state authorization. This is done by the states and is a state matter. So I want everybody to be aware that we get that question a lot. On a second point, the regulations provide for how various types of institutions would be considered to be legally authorized. Broadly, there are two parts for state authorization requirements for main campuses and other locations: the basis of the operating authority for the school and any required approvals from the state, and the state's process for student complaints. Related to state authorization, but actually not part of the state authorization regulations, are the student consumer information requirements, and they're a different part of the regulation. 600.9 covers state authorization, 668.43, in particular B, we'll talk about this later, are the parts related to the consumer information requirements. And we're going to touch back on all of this shortly when we return to state authorization in general, and state authorization of distance education in general. But let's talk about the lawsuit. This lawsuit started way back and was actually back in July of 2011. We were sued over these October 29, 2010 state authorization regulations. These final regulations contained rules regarding state authorization of distance education. However, these regulations regarding state authorization of distance education were not proposed in the notice of proposed rulemaking. Consequently, the court upheld the actual program integrity regulations with one exception, 600.9C, which concerned the state authorization of distance education on procedural grounds. The court vacated 600.9C and ruled that the department should have included the distance education provision in the proposed regulations. So, what did the department do? Well, of course, we conducted more negotiated rulemaking, and this was in 2014 and included, in part, state authorization of distance education for distance education providers as a component of institutional eligibility, and state authorization of foreign locations of domestic institutions. We published an NPRM on July 25, 2016, and final regulations on December 19, 2016. These are links to both of these final and notice of proposed rulemaking. The important one, of course, is the December 19, 2016 final regulation. So, what happened next? On July 3rd, 2018, with an effective date of July 29, 2018, we published a notice delaying the date of the amendments to 600.2, that's definitions, 600.9C, state authorization of distance education, 668.2, again with definitions, and the addition of 668.50. These pieces of that December regulations, the ones that were published December 19th, were delayed until July 1 of 2020. Section 600.9D, the section that dealt with state authorization for foreign locations of domestic institutions, went into effect as scheduled on July 1, 2018, and has been effective ever since. Very shortly thereafter, in August of 2018, the National Education Association, the California Teachers Association, and individual plaintiffs filed a challenge to the delay rule, which is what people started calling that particular notice. They asked for the delay rule to be vacated and that the December 2016 distance education rules be allowed to go into effect. Shortly thereafter, Ed established the Accreditation and Innovation Committee and conducted negotiator rulemaking from January to April of 2019. You heard some discussion about that earlier. State authorization of distance education and related disclosures were discussed as part of the Distance Learning and Innovation Subcommittee. This is one of the 3 subcommittees that was established, and along with faith-based entities and the Teach Grant program. There were 3 buckets of issues. We reached consensus. You heard all this. State authorization of distance education and related disclosures were part of the distance learning bucket. So you had 3 subcommittees and you had different buckets. In the meantime, on December 26, 2019, the court issued its memorandum opinion and order granting the plaintiff's motion for summary judgment and denying Ed's cross motion for summary judgment. So what this means is that while the negotiated rulemaking was going on, this was the decision that was made regarding the 2018 NEA, et cetera, challenge to the delay rule, where the plaintiffs asked that the delay rule be vacated and the December 2016 distance education rules be allowed to go into effect. And that's what the court did. The court vacated the delay rule, but stayed the vacatur for 30 days from the date of the order, which was April 26, 2019. But that's not it. In the meantime, this is like a saga that never ends. On June 12, 2019, the department published a notice of proposed rulemaking in the Federal Register that included the consensus language changes to the state authorization's distance ed rules and related disclosures. There's a link to that. And because of the court order, we then went ahead on July 29, 2019, publishing a Federal Register notice reflecting the court's decision and causing all kinds of confusion. Fortunately, we have published now final regulations as of November 1, 2019. And the link for that is on this slide. While the effective date of the final regulations is July 1, 2020, there are certain sections of the final regulations that we've designated for early implementation beginning on November 1, 2019. Effectively means that that's happening now. You can do these things now. So what are these things that you can do now? So each institution or agency may early implement the following sections as appropriate at its discretion. The 600.2 piece with the relevant definitions, the 600.9 piece, which involves state authorizations of distance education, section 668.43 as related to disclosures, and 668.50, which applied solely disclosures solely related to distance education, which you now don't actually have to do. And we'll talk about all that later if you decide to early implement. So, if you early implement, just to be clear, you could have done so as of November 1 of this year. If you need to document that you've done that, you would need to provide information should we ask. Otherwise, if you decide not to early implement these pieces, that would mean that you would have to comply with the December 2016 regulations until July 1 of 2020, at which point you'd have to comply with these new regulations anyway. So we're not telling schools what to do, but just so you understand your options. So let's talk a little bit about what was presented in the final regulations that are now effective. There was one piece that I wanted to bring to everyone's attention that even though it has really nothing to do directly with the state authorization regulations per se, we did modify one piece under 600.9b dealing with the definition of a religious institution. So now, an institution is considered to be legally authorized to operate educational programs beyond secondary education if it is exempt as a religious institution from state authorization under state constitution or by state law, but it must still provide a state complaint process. Why do we do this? We did this because in some states, not in every state, but in some states, the state definition of what it constitutes a religious institution in that state and the federal definition for what we use for institutional eligibility, they are not the same, and it makes it very difficult for those institutions to actually do the approval piece of the state authorization for an institution. So institutions were either having to get statutes changed or look for alternative ways. We do offer some alternative ways to do these things. And it was just generally felt that it makes no sense for our definition to be trumping the state's definition where that is where this institution is located, and the state actually has a definition of its own for a religious institution. So with all these things, we decided that we would make this change, and so now that is a final that has been made, a change has been made. Let's talk about the definition of state authorization reciprocity agreement. Now, in the notice of proposed rulemaking, we propose to generally maintain the definition as it was presented in the December 19, 2016 final regulations. However, a change was made to this definition in response to public comments from what was proposed in the NPRM. We were persuaded by commenters who suggested that we modify the definition to clarify that a state authorization reciprocity agreement cannot prohibit any member of a state from in the actual agreement from enforcing its own general purpose state laws and regulations outside of the state authorization of distance education. So the resulting definition is now this definition, which is different than the one in the NPRM, and it states, an agreement between two or more states that authorizes an institution located and legally authorized in a state covered by the agreement to provide post-secondary education through distance education or correspondence courses to students located in other states. So I've got located italicized. We're going to get back to that little point later. Covered by the agreement and cannot prohibit any member state of the agreement from enforcing its own general purpose state laws and regulations outside of the state authorization of distance education. So, effectively, a reciprocity agreement could supersede a state's own requirements related to state authorization of distance education and may prohibit a state voluntarily, because remember, these are voluntary agreements, participating in that agreement from adding additional requirement on institutions that also participate in the agreement. The idea was that adopting this definition would alleviate confusion about the definition, clarify the scope, whoops, do I have anything here? No. Clarify the scope of a state authorization reciprocity, that the scope of a state authorization reciprocity agreement cannot be interpreted to extend beyond the scope of state authorization of distance education or to impact a state's exercise of its other general oversight activities and permit a member state of the agreement to enforce its own general purpose state laws and regulations outside of state authorization of distance education, again, while replacing this potentially confusing and conflicting language in the existing definition. So the final regulations addressing state authorization of distance education are contained in 600.9C, just like we had addressed it earlier. So we did not create a new regulation section for this. We just put this one in there. The final regulations for this say that if an institution that meets the requirements under paragraph A1 or B, paragraphs A1 or B refer to the actual physical location regulations for state authorization. So if an institution that meets requirements under A1 or B offers post-secondary education through distance education or correspondence courses to students located in a state, located, not residing, which is a change we will talk about in a minute, in a state in which the institution is not physically located or in which the institution is otherwise subject to that state's jurisdiction as determined by the state, except as provided in paragraph C1II of this section. C1II of this section, as we will shortly see, refers to the reciprocity agreements. The state must meet any of that state requirements for it to be legally offering post-secondary distance education or correspondence courses in that state. And the institution must, upon request, document the state's approval to the secretary. So I'm going to stop there for just 1 second. So basically, if you're not in a reciprocity agreement and you want to offer distance ed, this is your section. On the other side, if an institution meets the requirements under A1 or B and offers post-secondary education through distance ed or correspondence in courses in a state that participates in a state authorization reciprocity agreement, and the institution is covered by such an agreement, the institution is considered to meet state requirements for it to be legally offering post-secondary distance ed or correspondence courses in a state, subject to any limitations in that agreement and to any additional requirements in that state not relating to state authorization of distance education. And again, it would also have to, the institution would also have to document this information. So, in the revisions, we revised these to be consistent with the revised definition of a state authorization reciprocity agreement, and provides that an institution covered by a reciprocity agreement is considered to meet state requirements for it to be legally offering post-secondary distance education or correspondence courses in a state, subject to any limitations in the agreement and to any additional requirements of the state that do not relate to distance authorization of distance education. Right. Okay. So, we also want to note that the revisions to the regulations apply to the schools that are authorized under A1 or B of 600.9. They refer to a student's location, not residence, and the reference to location, not residence, is also reflected in the state authorization reciprocity agreement definition, which I previously pointed out so that you would have that information. With respect to determining students' location, the institution would determine a student's location at the time of initial enrollment based on information provided by the student and also upon receipt of information from the student that their location has changed in accordance with the institution's procedures. Institutions, however, are able to develop procedures for determining student location that are best suited to their own organization and the student population they serve. So for instance, a school could, if they wanted to, make different determinations for undergraduate versus graduate students. Regardless, institutions must apply these consistent policies and procedures regarding student location to all students, including students located in brick and mortar institutions. And upon request, provide the secretary with the written documentation of its determination of a student's location and including the basis for that determination. couple other important pieces that were done. One, the regulations for a state complaint process under 600.9C2 have been removed. There are two places where the state complaint process continues to reside. One is under 600.9A1, which is the basic state authorization regulations that we discussed way earlier in the beginning. And in addition, in 668.43B, which we will discuss in a little bit. Now, having said this, remember, these are state matters, so nothing actually prevents a state from providing a state complaint process that an institution offering distance education would have to comply with in order to operate in that state, unless the state and the institution both have joined a reciprocity agreement that provides an alternative means of addressing student complaints. So, there's some decisions that people will have to make regarding how they want to approach these things. So we talked about this 668.43B disclosure that requires an institution to provide students and prospective students with contact information for filing complaints with its state approval or licensing entity and any other relevant state official or agency that would appropriately handle a student's complaint. These regulations have been in effect, for a really long time, way back, even 2010 regulations, these were in there. So this is not anything new. The disclosures that were related to distance education under 668.50 had applied solely to the distance education providers, and these were what was removed as part of the consensus language during the negotiated rulemaking. However, there are in some cases some similar, wow, what just happened? Some similar disclosures under 668.43, and these apply to all institutions. So what I wanted to do here was just show you where some of these things sort of kind of ended up, if they ended up anywhere. Some did not. So when we had the public disclosure piece, and for prior institutional disclosures required under 668.50 for public, again, there is no disclosure specific to distance ed in the current regs. But for this disclosure, whether the institution is authorized by the state to enroll students where they reside, whether that authorization is through a reciprocity agreement, the consequence if a student moves to a state where the institution is not authorized. What we have here that's similar to that is that the institutions are required to disclose information about state authorization under 668.43B, which we just discussed. The state-based complaint process for each state in which the institutions reside, including consumer complaints. Now, institutions are required to provide information about 6 state complaint-based systems under 34 CFR 668.43B, so same as the first one. For any adverse actions a state has initiated related to distance education or correspondence programs, or any adverse action an accrediting agency has initiated related to distance ed or correspondence programs. What we have now is an institution being required to give notice to students if an enforcement action or prosecution is brought against the institution by a state or federal law enforcement agency in any matter where a final judgment against the institution, if rendered, would result in an adverse action by an accrediting agency against the institution, revocation of state authorization or limitation, suspension, or termination of eligibility under Title IV. Again, this is not taking us back under 668.43A 20. Refund policies with which the institution is required to comply by any state in which the institution's students reside. Now, an institution is required to disclose all state refund policies it must comply with under 668.43A2. Applicable educational prerequisites for state licensure or certification in each state in which its students reside or any other state where it has made a determination about these requirements. Institutions must also disclose whether those programs meet such requirements, or if the institution has not determined whether the program meets those requirements. Now, if an educational program is designed to or is advertised to meet educational requirements for a specific professional license or certification required for employment in occupation, the institution must disclose if program completion is sufficient to meet licensure requirements in a state for that occupation, including a list of all states that the institution has determined its program will meet, will not meet, or if it has not made a determination regarding the requirements. So, these are individualized disclosures now that were used to exist in the prior regulations, where an institution was required to make individualized disclosures to prospective students in DE or correspondence programs if the program the students are investigating do not meet licensure or certification prerequisites in the states in which students reside, and must obtain acknowledgement from the student that they received this. Now, an institution must make individualized disclosures to prospective students for any program designed or advertised to meet state licensure requirements when its program would not meet educational requirements for licensure in the state where the students are located, or if the institution has not determined if the program would meet such requirements prior to a student's enrollment in the program. There is no requirement for documentation of a student's acknowledgement of such disclosures. Where an institution is previously required to make individualized disclosures in enrolled or prospective students in distance or correspondence programs about any adverse action a state or accrediting agency has taken within 30 days of the institution's becoming aware of such action, we have no current similar individualized disclosure. And where an institution was required to make individualized disclosures to enrolled or prospective students in distance or correspondence if it determines its program no longer meets state's licensure requirements within 14 days of making such determination, the institution is now required to make these individualized disclosures to enrolled students in any program designed or advertised to meet state licensure requirements, again, if the institution determines the program no longer meets such requirements in a state where the student is located within 14 calendar days of the determination. With respect to student location and disclosures, the individualized disclosures related to licensure or certification must be made directly to a student in writing, and that can be through email. That would be fine. Whoops, I didn't mean to do that. And the institution would parallel in terms of determining the student location what we had just previously discussed, where it determines a student's location using a process that would be applied to all students and makes that determination at the time of a student's initial enrollment and upon formal receipt of information from the student that the student's location has changed to another state. And finally, the institution must, upon request, provide written documentation of its determination of the student's location, including the basis for such determination, just as we had previously discussed. So, this part concludes the state authorization for distance education portion of the presentation. One last reminder before we go on to the distance education portion of our presentation. The state authorization distance education portion concerns final regulations effective July 1 of 2020, though institutions may implement early, as discussed. Please keep this distinction in mind when the other part of the presentation is going on. So, at this point, I'm going to turn the presentation over to Greg and David, who are going to provide the update on distance education.
Thank you, Sophia. I appreciate that. As Sophia pointed out, as we look on this next slide here, the following slides are based on draft consensus language resulting from Session 4 of the negotiated rulemaking that we did concluding last spring. So as you know, there was negotiated rulemaking. There were 3 subcommittees involved. This is from the Distance and Innovation Subcommittee. So I've given you a link here to the language that you can find on the ed.gov website. And the only reason, I'll be honest with you, this is the first time in 30 years I've ever presented on language that was draft consensus language and wasn't at least in an NPRM. The reason we can do that is because consensus was reached, but as Sophia pointed out, we don't even have an NPRM on this yet. So this part of the presentation is going to be a little bit different. We're just going to give you a high-level overview of what you can expect maybe in the NPRM, but we do expect to publish an NPRM in the next couple of months, and at that point you will get an opportunity to comment. Because of that, we can't entertain any questions today about what might be different in these rules when they reach their final form. Obviously, the NPRM will reflect what the consensus language was. There'll be a discussion period, there'll be rather a comment period, and then final rules issued. But we'll just go over what's in it so you can get an idea of what we did in negotiated rulemaking with distance education. First thing I want to talk about is academic engagement. And currently, we do not have a definition of academic engagement. The only area we reference this in would be in the R2T4 regulations in 668.22. And they relate to activities that can be considered academic attendance or attendance in an academically related activity for determining when a student has withdrawn, or the withdrawal date for the purposes of 668.22. And as pointed out there, it only pertains to R2T4. So what we've done here is moved most of what's in 668.22 L7 related to the requirements for academic attendance and attendance in an academically related activity. And we've incorporated those into a new definition of academic engagement that has now been moved to Part 600. So it is going to be applicable to R2T4, but is also going to have other applications as well within Part 600 and Part 668. So it's a much broader definition now. And it's going to specify that academic engagement includes interactive tutorials or webinars. Again, what we're trying to do here is show you what part of, and I should have pointed that out earlier, that this is not a complete overview of distance and innovation, what happened in that subcommittee, only the aspects of it that relate particularly or specifically to distance education. So you can see here that what we did in modernizing this rule was to take into account different types of education, the increasing prevalence of distance education. So we're specifying that academic engagement does include interactive tutorials or webinars, and we clarify here that merely logging into a class or an online tutorial does not constitute academic engagement. One of the other areas where consensus was reached, and again, you can see all of this in the consensus language if you choose to go to that website and follow the link. We now have a clock hour definition that incorporates the distance education and also acknowledges that distance education can be taught via a clock hour program. We've never prohibited that, but the absence of anything in regulations referring to it led to a lot of questions that we entertained over the previous 10 years or so about whether or not a program offered in clock hours could be distance and how that would work. So we clarify here a 50 to 60 minute period, 50 to 60 minutes rather, within a 60-minute period. Any of you who do clock hours will recognize that definition. Of attendance in a synchronous class, so we point out that it would have to be a synchronous class, lecture or recitation where there's an opportunity for direct interaction between the instructor and students. And it does clarify that distance education may be offered via clock hour. And it requires institutions to be capable of monitoring the students' participation during 50 out of 60 minutes in each hour. We also have in this regulation that it must meet all accrediting agency and state requirements and not exceed the restriction on the number of clock hours in a program that may be offered through distance education. We also have some clarifications in in the draft language. I don't want to say proposed because it isn't proposed. That would not be appropriate. But on my tongue is always that word proposed, and I have to fight the urge to say that. So a correspondence course is defined. The definition refers to instructors rather than instructors. So we're switching away from just this viewpoint of one instructor to recognizing that coursework can be taught in a variety of different ways and increasingly is offered through the involvement of many instructors, not just one. The reference to correspondence programs being self-paced is removed. So no longer will a definition of a correspondence course be tied to its being self-paced. And we are defining a correspondence student as one whose enrollment in a correspondence course constitutes more than 50% of the courses in which the student is enrolled during the award year. Currently, the regulations don't define correspondence student, what that means, and so that has some ramifications, so we wanted to make it clear what an actual correspondence student is. Moving on to distance education. The definition of distance education would refer to instructors or instructor rather than simply instructor. I just explained on a previous slide that we are looking at this in a more holistic way and making accommodations for some of the innovations that have occurred in the delivery of distance education. We also eliminate references to various types of media that we described under the current definition because these are, they are referenced in statute, that's true. But I think all of you will agree that many of these forms of communication are somewhat outdated. Though I have a real love for CD-ROMs back in my heyday in the 90s, those figured very, very strongly into things. And technology has passed me by, and so therefore we're removing this from. So we're replaced with the phrase other media, which is more all-encompassing and will accommodate any advances in technology that occur. It could be 20 years from now. We look at the technology we're using now and laugh at the terms that we currently use. I'll probably be in a nursing home at that point, but others of you may be here to laugh. We would define an instructor as an individual responsible for delivering course content who meets the qualifications for instruction established by the institution's accrediting agency. So moving to what we would consider an instructor to be. The phrase substantive interaction is one that has caused, certainly precipitated a lot of discussion over the years. It is used in statute, but we are, for the first time, defining that here. Defined under distance education as engaging students in teaching, learning, and assessment consistent with the content under discussion, and including two of the following. So you see 3 bullets there. So for it to be considered substantive interaction, it would have to include 2 of those 3 bullets. So providing direct instruction, assessing and providing feedback on a student's coursework, providing information, responding to questions about the content of a course or competency, facilitating a group discussion regarding the content, or other instructional activities approved by the institution or program's accrediting agency. So it's a bit of a broader look at what substantive interaction would be than perhaps we had in the past, but again, accommodating for some of the innovations that have occurred with the delivery of distance education. So with distance education, in the law, it refers to regular and substantive. So we discussed substantive, and now I'll move to how we dealt with the requirement for that interaction to be regular in our negotiations and the subsequent consensus language. So prior to the student's completion of a course or competency, providing the opportunity for substantive interactions with the student on a predictable and regular basis, commensurate with the length of time and the amount of the content in the course or competency, and to monitor the student's academic engagement and success and ensure the instructor is responsible for proactively engaging in that substantive interaction when needed or upon request. And that might seem a little bit wordy, but what we wanted to get away from was this idea that regular interaction occurs if it occurs 2 times every week, or what if it only occurs 1 time this week but 2 times the next week, or 8 times over the whole semester. So that whole discussion seemed to be somewhat absurd and was not really yielding anything in the way of something that schools could use. So we moved to, I think, a more practical definition of regular interaction. Direct assessment programs. We still have retain the definition of direct assessment in the regulations that comes from statute. This has to do with when department approval would be required for direct assessment programs. So in this consensus language, if it became regulation the way you see it here, department approval would be required for the institution's first direct assessment program, and when the institution offers a direct assessment program at a different level of offering. For example, a first direct assessment program at the master's degree level following offering one at the bachelor's degree program. So we would say bachelor's was previously approved with the first direct assessment program, so the school could have added other direct assessment programs at the baccalaureate level that would not require additional approvals from the department, and now they want to offer one at the master's level, and since that's a different degree of offering, it would require the department's approval. So as we just said, additional programs at the same credential level would not require the department's approval. Any additional programs must, however, be reported to the department within 10 days after the change, or I should say would have to be reported as it is currently in the mandatory language. Institutions would be required to explain how they exclude credits earned through prior learning assessment from consideration of the student's eligibility for Title IV aid. Remember, we do not pay for any credits that are learned prior to the student coming, or anything prior to the student coming to this program, or for any type of testing that tested a student out of credits. And finally, would permit preparatory coursework and coursework required by the state for teacher certification to be offered using direct assessment, and would permit programs offered in part through credit or clock hours and in part through credit or clock hour equivalencies. So this is a bit of a broadening of the current regulation as well. We require the institution to establish a methodology to reasonably equate each module in the direct assessment program to either credit or clock hours. And they would not be permitted to switch between clock and credit hour equivalencies. Okay, I'm going to turn it over to David to discuss subscription-based programs.
All right, thanks, Greg. Can everybody still hear me? I'm not sure this one is. Yeah, there we go. Speak and ye shall receive. So I'm going to talk a little bit about some other changes that were made for direct assessment programs. Specifically, the committee agreed to create a new disbursement process for what they called a subscription-based program. And a subscription-based program is a standard or non-standard term direct assessment program where the institution charges a student in each term on a subscription basis to complete as much coursework as the student is able to complete during that period. In many of these kinds of programs, there's no set courses that the student is taking during a subscription period. The student simply signs up for the courses that he or she wants to participate in and works on them at the pace that the student chooses. So in the committee's agreement, in a subscription-based program, coursework would not be required to begin or end within a specific time frame. And that's the normal requirement for a term-based program, is that all of the coursework in that term must begin and end within the term dates. In a subscription-based program, that would not be true. The expectation would be that a student completes a specific number of credits during the term, but not a specific set of courses. So for example, you would need to keep working on coursework, but whether you started the course at the beginning of the subscription period or not would be irrelevant. The requirement would just be that you are staying on pace and completing a certain number of courses in general. Students would have to complete a cumulative number of credits during or following the end of the term before receiving subsequent disbursements of aid. So similar to how non-term programs, both credit hour and clock hour, work today, there would be a standard that students would have to meet in terms of completion before they get subsequent disbursements of aid. The other requirement that the committee has agreed to create was that the institution would have to establish a single enrollment status that would apply to the student throughout the program. So that's very different from what a traditional program might look like. Normally in a traditional program, a student signs up for a certain number of courses, and that defines their enrollment status for that period. In a subscription-based program, however, a student would simply be assigned a enrollment status that applies throughout the program, for example, full-time, three-quarters time, half-time, and that's essentially treating the program as a full-time program or a half-time program. All the students in that program would have the same enrollment status and would be held to the same standard for completing coursework. The draft regulations would establish a method for determining the number of hours that a student has to complete before receiving subsequent disbursements. And essentially, it would involve the institution determining for every term the minimum number of hours that would be required for the student's enrollment status, and then adding together all of the hours in prior periods that the student has enrolled and attended, excluding, and this is important, excluding the current and most recently attended terms. So what that means is that in the very first term, so that's the current term, there would be no completion requirement. And then in the next term, so let's say if you started in the fall, if you got into the spring subscription period, there would also be no consideration of prior terms. But then once you got to the third term, the student would be required to complete, and let's take an example. Let's say that a school had a half-time program and defined its full-time status as 12 credit hours. That means that half-time status for that school would be 6 credit hours. So in that case, after that third subscription period, the student would have to have completed at least six credit hours in order to get their next disbursement. After the fourth subscription period, they would have had to have completed 12. After the fifth, they'd have to have completed 18, and so on and so forth until the student finishes the program. So the idea is that it's a somewhat more flexible way of approaching terms that is a little bit like the non-term completion-based standard that we have for non-term and credit hour and clock hour programs. So the reasons that the committee came up with this idea is that the current requirements for disbursement in term-based and non-term programs make it somewhat difficult for direct assessment and competency-based programs writ large to implement the Title IV aid programs. If you require coursework to start and end within the same subscription period, you limit the student's opportunities to take other kinds of coursework at the student's own time of choosing. And if you require a school to use the non-term system, they're limited to a very specific kind of measurement of completion that doesn't give as much flexibility as these draft rules would. The draft rules would allow essentially treating a subscription period as a payment period. So to summarize, the subscription-based disbursement method would require a student to complete a certain number of competencies in past subscription periods in order to keep getting aid. There would be no requirement to complete specific competencies. As I mentioned, this is a general completion requirement of any courses that are required for the program. And it would permit coursework that overlaps or extends beyond the payment period start and end dates. So it gives a lot more flexibility about when the student is starting and ending their coursework in these programs. It does allow Title IV disbursements at the start of each subscription period, which again is synonymous with payment period. It requires the student to have completed the credit hours or equivalent associated with that enrollment status, as I just mentioned. And there's a lot more flexibility over the current rules for self-paced programs that require completion of 1/2 hours and weeks in the academic year for a second disbursement in a traditional, we'll call it traditional, I guess, a non-term credit hour program. So there would be some restrictions that are placed on subscription-based programs that the committee agreed to. Subscription-based programs are only direct assessment programs. So under the draft rule, this would only apply if you had a direct assessment program that had been approved by the department. And you'd have to be offering you have to be charging students on a subscription basis and expecting that a student completed a certain number of competencies in each term. Another restriction is that repeated coursework can't be included in a student's enrollment status in this system. So as you are probably familiar, in a traditional term-based environment, a student can pass, and then take the same course again, even after passing it once more, and receive Title IV aid for that course. But that would not be permitted in a subscription-based program, mostly because the department and negotiators agreed that it would be a lot easier to abuse that system, to have students working on competencies here and there, and even after completing them, having them redo them. So that would not be permitted. And as I mentioned before, a school has to establish a single enrollment status that applies to a student throughout the program. So some other changes that the committee agreed to make were related to satisfactory academic progress. And here, the committee made changes that applied both to direct assessment programs and programs in general. So some of these changes are going to be specific to subscription-based programs, the new programs that we just discussed, and others are going to apply to all programs. So it's important to keep the distinction in mind. For subscription-based programs, there will be no SAP PACE evaluation required, and that's mostly because students in such programs have a completion requirement built in. They have to complete a certain number of competencies in order to continue receiving Title IV aid. So schools won't be required to complete a quantitative evaluation of their progress for SAP purposes. They would still have to complete a qualitative evaluation for subscription-based programs, but not, and they would be tied to a maximum time frame, but there would not be a PACE evaluation. And a student wouldn't be able to receive a subsequent disbursement, as I mentioned, because a student is held to that completion standard. So the subscription-based programs are treated a little bit like how the committee proposed to treat non-term credit hour and clock hour programs. So just like I said before with subscription-based programs, the draft rule would make a major change and state that for non-term credit hour and clock hour programs, and that's all non-term credit hour and clock hour programs, no SAP PACE evaluation would be required. So for those programs, just like subscription-based programs, students have to complete credits and complete coursework in order to get subsequent disbursements of Title IV aid. And the department agreed with negotiators that this is a sufficient mechanism to ensure that students are indeed progressing through their program. Students would not be able to receive a subsequent disbursement until at least 1/2 the hours of the weeks in the academic year are successfully completed, and that's the current rule. The maximum time frame would still apply. It would still be required for all programs, so a school would have to monitor that, just like they do today. And undergraduate programs measured in credit hours would have a new option, and this is another big change. Under the draft rules, credit hour programs could choose to either monitor a student's pace, or they could either monitor a maximum time frame in calendar time or in terms of completed credit hours. So it's another bit of flexibility for schools if they don't want to use credit hours as the determinant for maximum time frame. So GPA requirements would remain unchanged. That'll be applicable to all programs. A SAP policy still has to specify the GPA or comparable assessment that a student is required to achieve at each evaluation. And for a program of more than 2 academic years, that by the end of the 2nd academic year, the student must have a GPA of at least C or its equivalent, or academic standing consistent with graduation requirements. And this is straight out of the law, so these are things that we really can't change. So then the committee also agreed to make a few conforming changes to the regulations for appeals of final audit determinations. And these conforming changes are really just a recognition that many of the department's requirements relate to the requirements of accrediting agencies and states. And so any of the department's regulations related to, just for example, distance education or the assignment of credit hours that rely on another oversight entity like an accrediting agency or a state, when the department is evaluating an appeal of a final audit determination or a program review, for example, once the department has come in and actually evaluated the school's compliance, the department has to rely on the accrediting agency or state's requirements. It can't use its own requirements. It has to look at those other agencies' requirements that are connected in these regulations. All right, so the last thing I want to talk about are a number of new draft rules that the committee agreed on relating to return of Title IV. And as you guys all know, I'm sure, return of Title IV funds is the process that takes place when a student withdraws, and the school is required to determine the amount of a period the student completed in order to determine whether any returns are necessary. So under the draft rules the committee agreed on, they've decided to eliminate the concept of modules for non-term or subscription-based programs. And that was really with a recognition that the modular requirements are aimed at traditional term-based programs and really they don't apply very well to non-term programs. So the department, in agreement with negotiators, decided that we would remove all references to modules for non-term programs, and we would not make any for subscription-based programs, but we wanted to replace those wherever they appeared with some new requirement that would replace what was removed. So you guys may know that if a student ceases attendance in a non-term credit hour program or a non-standard term program and is unable to resume attendance within that payment period in a module that begins no later than 45 days after the end of the current module, then the student has to be considered withdrawn. So again, because we're getting rid of the concept of modules, we tried to simplify this so that in the draft rule, if a student is unable to resume attendance within a payment period for more than 60 calendar days after ceasing attendance, they have to be considered withdrawn. Otherwise, the student might be able to give a written confirmation of return and not be considered withdrawn while you're waiting for them to come back. Additionally, a student enrolled in subscription-based programs could only avoid withdrawal through a written confirmation of future attendance if the student indicates their intent to resume attendance during the same payment period or period of enrollment. And that's really just intended to ensure that students don't go beyond the end of a subscription period unless they take a leave of absence, which I'll explain in just a second. So keeping with the same theme, for non-term and subscription-based programs, the student would be permitted to change his or her date of return. Again, this is a case where a student has ceased attendance, given a written confirmation that they're going to return in the same period, and then wants to change it. And we simply replace the old 45-day requirement with this requirement that says that as long as the return is no later than 60 calendar days after the student ceased attendance. So this second bullet here is a really big change. So one of the other things that the committee agreed on was they wanted to deal with some issues related to how students are treated as withdrawals when they complete modules in programs offered in modules. So these are term-based programs, standard or non-standard term programs. So the committee agreed to loosen the department's requirements for when a student had to be considered withdrawn. So they did that in a number of ways. So first, if the student has completed all the requirements for graduation from a program before completing the number of days that they were scheduled to complete, that student's not a withdrawal. The student completed their program. It seems very strange to consider that student a withdrawal when they've actually completed their entire course of study. So that was one way that we are removing that requirement that may exist under the current rules. Under the draft rules, in a program offered in modules, if the student completes one module that includes at least, or a combination of modules that includes at least 50% or more of the number of days in the payment period or period of enrollment, then the student is considered to have completed. So for example, if you have 3 modules in your summer period and the student completes both the first and second modules, and those modules constitute, let's say, 67% of the summer, then your student is considered a completer, even if the student, when they left, was scheduled to attend that last module. Under the current rules, if you have a student who completes a module, but at the time of completion and the time that they cease attendance, they're still scheduled to complete a future module, they might end up being considered withdrawn. So this would eliminate that possibility if a student completes a substantial part of the payment period. And the final change would be that if a student completes coursework equal to or greater than what's required for half time for the payment period, let's say the student completes 6 credits in that first module of 3 in that summer, in that imaginary summer that I just described, that student also would not be considered withdrawn, even if they were scheduled to attend other modules in the same payment period. So the department agreed with negotiators to try and limit the number of cases where we treat students as withdrawn, even though they've actually completed coursework during a payment period. And finally, the last item here, in a subscription-based program, because we had to deal with this as well since we're creating this new subscription-based framework, they're added to the types of programs that don't require the student to come back and complete coursework that they were working on prior to a leave of absence. And this is intended to give schools some flexibility in how they treat students who want to go on a leave of absence in the middle of a subscription period and come back in a later subscription period, because subscription-based programs really don't have set coursework that a student is working on. All right, and that is the end of our presentation today. I want to just make one more reminder that the all of the issues that Greg and I discussed about the distance education agreements are not final rules. They are not applicable today, and they haven't even been published in an NPRM yet. So neither Greg nor I will be allowed to discuss those requirements or take comments about that. So keep your questions limited to the issues that Sophia described about the current rules, and if you want to ask questions about what the committee agreed on, we can answer those about what's been presented here today. And so, if you'd like to ask questions, we'd ask that you come up to the mic, which is over here in the very middle of the room, and please just line up so that we can take each of your questions in turn. We only have a few minutes, so I hope that if you guys do have questions that we can get to them, but we will do our best and get through them as quickly as we can. Yeah, go ahead.
Just one more thing, if for some reason you do have questions, we don't have an opportunity to get to them, we do have our contact information on the next page, so you can email us any questions. And specifically, if it's something that's very case-specific in your case, it's usually better to email the person to get an answer to your question. But having said all that.
I just have a general question. Are these slides going to be available later on for us to access from our home schools?
Yes. Yeah, they're already up on the department's FSA conferences.ed.gov website. You can get them right now.
Thank you.
Sure.
Can you go back to the slide about the mod, R2T4 mod changes, the last 2 bullet points? Those last 2 bullet points are kind of huge. Are they in effect right now, or are they happening when the rules come out?
So, yeah, as we mentioned, these are not in effect right now. These are not, they haven't even been published in a notice of public rulemaking.
Okay.
They were part of the agreement and the consensus with the negotiators and the federal government during the negotiated rulemaking process. So what will happen is we will publish a notice of public rulemaking that it actually explains these rules, explains the department's reasoning for them, explains the negotiators' perspectives, and then you'll have a chance to comment on those rules before a final rule is published.
Okay.
So that's good. That process is going to take many more months during this year and next.
Okay, great. Okay, thank you.
Thanks. All right. And looks like if we have no other questions, thank you very much. We appreciate your attendance today.